What is a will? A will is a document where you get to say who gets what and who is in charge of making that happen after you die. Someone named in a will to receive your assets is called an heir or a beneficiary, and the person put in charge of making that happen is called a personal representative or an executor. However, it's important to note that wills do not apply to assets where you have a surviving joint owner of the asset, nor does a will apply to assets where you have a living designated beneficiary. For example, on retirement accounts and life insurance, if you have your spouse named and then your children as beneficiaries, then that asset will be payable directly to the living beneficiary who is named separately in those designations, regardless of what any will says. If you have a will is really critical to your estate plan, and you need to ensure that it is in sync with everything where you have a beneficiary named and with any other estate planning documents to make sure it is all working together according to your wishes. Also, for any property passing under a will, it's important to understand that that will has to be submitted to a probate court and reviewed and approved by the court before anyone named in the will can gather your assets, pay any creditors who might be owed money, and then ultimately distribute the remainder of your money and property to your heirs. A will is a document that does have to go through probate. Because we run across a common misconception on this issue, I'll repeat that. Wills do not avoid probate. Some people essentially think of a will as a kind of magical document that covers every estate planning scenario, but it doesn't. It's critical and you need it, but you need to make sure that you understand that if the will is the document determining who receives your money and property, then a court process with court fees, attorney's fees, and executor's fees is required. And it can often take 9, 14, 18 months or more before your will is legally effective. That said, if a will can't avoid probate, is it possible for you and your family to avoid probate in some other way? The answer is yes, it is.